Hi everyone, happy Friday. It's Aisha Chidilwe here. I'm a trademark attorney here in Orlando, Florida, but I represent clients all over the United States and internationally. As long as you have a trademark that you would like to protect here in the United States, or you intend to do business here in the United States and you want to protect your trademark, I'm definitely able to help you. So welcome to Lipsticks and Trademarks. Lipsticks and Trademark is a weekly show that I offer every Friday, where I talk about all things lipstick and a pertinent topic in trademark that business owners or trademark owners want to find out about. So, the first thing I want to talk about is what lipstick I'm wearing today. Today, I'm wearing a MAC Retro Matte, and it's called Tailored to Tease. I'm sure by now you guys would have noticed that I love to wear retro matte lipsticks. I generally love to wear them because I talk all the time and I'm meeting with clients all the time, and I don't want to wonder or worry if there's lipstick on my teeth or if I eat something like it's on my face. But this stays on matte, and so you barely ever have to touch up. So let's get that out of the way. So today I want to talk about the trademark wars between the Obamas. Yes, the Obamas and Hanisya Massey. So let me give you guys a little bit of a background story. So Hanisya Massey, and if you're listening, Hanisya, I do apologize for pronouncing your name badly. Basically had a trademark registered called Higher Ground Enterprises, which is in a class that basically category for ebooks, audio, illustration, and music. And she put in her application in December of 2016, and it got registered in 2017. And then, as most of you know, unless, maybe you live under a rock or you just don't watch news, during the election in 2016, a famous phrase that Michelle Obama started using it was, when they go low, we go high. So in combination with that phrase high, and with being influenced by Stevie Wonder's song Higher Ground, they decided to register their name, Higher Ground, for their new media production company called Higher Ground Production. So they're registering Higher Grounds. And this is in conjunction with the deal that they've got from Netflix to produce, shows and, things of that nature. So, the Obamas doing what any diligent business owner will attempt to do, was they tried to register their trademark. And in registering their trademark, they received an initial Section 2D denial, basically stating that, their mark would be denied due to likelihood of confusion between Higher Grounds, the Obama's mark, and Higher Grounds Enterprises, the mark of Hanisya, who, had registered her mark, prior to the Obamas. And so the Obamas, via their attorney, basically filed a response saying that, there's no likelihood of confusion because, when somebody's thinking of media production company, it's more of a sophisticated user, and there's no way that they're going to associate it with an ebook company or a music company or an illustration company. Basically, they were saying that the channels of trade and commerce are separate, and users or consumers will not be confused by the two brands. But the USPTO was definitely not convinced with that, and they still stood by their denial, saying that, it's not only about protecting consumer or buyer confusion, but they also want to protect the registrant from any sort of adverse commercial impact due to use of a similar mark, and especially with such a big giant. The Obamas are kind of no stranger to anybody in the world, so they just didn't want that to affect them. So now, once they got that, second basically refusal, the Obamas, via their attorney, decided to file a cancellation of the other trademark. Now, that is the meat of what today's topic is about. So of course, Hanisya's attorney is enraged and feels that, the Obamas are bullying Hanisya, a smaller company who has done things the right way and has registered her trademark. And, words he used are words like, they're being deplorable, and what happens now when they go, why are they now taking a higher road? So what I want to talk about today is, can the Obamas do this? Can they cancel somebody's mark who was registered before theirs just because they have a mark that they want to register? So what their complaint is alleging, to the USPTO in requesting that cancellation of the other mark that, does ebooks and audio and illustration, is that that mark should be canceled on the basis of it not having been used prior to them filing the application. So essentially, there are two ways to file a trademark application: an intent to use application or an actual use application. And so these people in December filed a trademark saying that their mark was in actual use, and the Obamas are basically alleging that that mark was not in use at that time. And so basically it's sort of fraudulent, allegedly. So what does this mean? Let me first talk about, can you cancel a trademark? And if you can, what are the ways you can do it? So yes, you can actually get a trademark canceled. So it's not just enough that you have a trademark, but you need to be very vigilant in policing your mark or taking, care of the following steps that I'm going to talk about, or your mark could get canceled. So one way to cancel your mark is that within 5 years of registration of your mark, another user or another owner of a mark who has a similar mark to you can file for cancellation based on priority of use. So let's say, you registered your trademark in 2018, and that other user or business owner can provide proof that they started using their mark in 2014. You can get your mark canceled in that situation. The other way is through abandonment. If you've abandoned your mark for 3 consecutive years, then your mark can get canceled. The other way is, if your mark becomes descriptive or generic, your mark can get canceled. And then, of course, the final one is fraud in acquiring the registration, which is what, Obama via their attorneys are alleging here, that basically these people, or Hanisya basically said she was using the mark, but really she wasn't. That being said, her lawyer alleges that, she's been using the mark since 2008. So now it behooves her and her attorney to provide that paper trail or that proof that they've been using the mark since 2008 in order to prevent that mark from being canceled. So I've said all this. And so what really is the moral of this story for other people who are not necessarily as popular? A lot of times, people come to me, especially small business owners, and when I talk about intellectual property, have you protected your intellectual property? Have you protected your trademark? The most common response is, I'm a small company. Once I start making money, I'm going to protect my brand. So this is a perfect example of why you should protect your brand as small as you are, or in fact, the smaller you are, the better, because, you have less to lose. In a situation like this, Hanisya has a lot of options. If she can provide documentation, she can use it as leverage and say, if you guys want this mark, purchase my company for X amount of dollars. Or she can say, I will agree to a coexistence agreement, but you need to pay me X amount of dollars. Or she can fight it all the way out. But the bottom line is, if you're a small business owner and you do things the right way, so you might not have a big budget like, the bigger companies that can basically hire lawyers and they'll bring out the big guns or they'll try to bully you. But what you do have is you have the protection of the United States Patent Office. So you have your registered trademark and you have examining attorneys who are looking out for you to make sure that people don't come and bully you. Basically, they have to show why that mark, should be canceled, or why that mark, why their own mark should be registered. So, it will definitely be interesting to watch to see how this gets resolved. And I will definitely keep you guys updated once I find out. So again, if you're a small business owner and you have a business that's worth protecting, which you should if you're a small business owner, you should definitely consider registering your trademark, because your trademark is your goodwill, and it's probably going to be the first things of value, that you're ever going to have in your business, outside of course your business profits. But when you start, that intellectual property is leverage that you can use in situations like this, and when you're selling your businesses and things of that nature. Well, So on that note, as always, I'm an attorney, but I'm not your attorney. This information is for educational purposes only and not legal advice. I'm just bringing the news to you and why it's important to protect your intellectual property. If you have any questions, comment below, send me a DM, or you can definitely call my office 407-995-6567. All right, talk to you guys soon.